Hello everybody and welcome. My name's Tony Burke. I'd like to welcome you all to this Burke & Associates video presentation. Today we're talking about some very recent and significant changes to the law affecting landlords and tenants in the commercial realm. As I mentioned, my name's Tony Burke. I'm a consultant with Burke & Associates Lawyers. In the past I've chaired SME committees for lawyers at both the state and the federal level. I was also president of Victoria's Law Society back in 2008, and I'm a trained mediator. Today I'm joined by two highly experienced fellow lawyers. To my left, to your right, I have Annabelle Viner, and to my right I have Megan Warren, and they're both members of the team at Burke & Associates, and we're very proud to have them here. Megan's a rare lawyer. She's admitted to practice in both Australia and in the US, which is extremely rare. She's also the chair of the national body which represents SME lawyers at the federal level, and she's on the executive of the Law Institute of Victoria, so a lady on the go. Annabelle is a property lawyer with a focus on planning and development, and she's had extensive experience in dispute resolution and associated issues. Now Megan, why are we here today?
Well, Tony, we're in the middle of a coronavirus pandemic, which is causing chaos in our economy and hurting a lot of people. Many businesses are suffering quite badly, and in response to that, the Prime Minister has announced some far-reaching changes which will have a great impact on many landlords and tenants.
I think he talked about a code of conduct or something similar, is that right?
Yep, we'll get to that, yep.
Okay, so what's this got to do with lawyers, Annabelle?
Well, Tony, on the 3rd of April this year, the Prime Minister, Scott Morrison, he issued a media statement regarding a range of matters that are intended to take effect from that day. But the important thing is he announced that the National Cabinet had, which involves state and territory leaders, had made progress on issues relating to commercial tenancies. He said that the National Cabinet had agreed to a mandatory code of conduct for negotiations between landlord and tenants, guided by a set of principles. He said that this will apply to tenancies where the tenant is firstly eligible for the Commonwealth's JobKeeper Assistance program and also as a small or medium-sized enterprise.
Now Megan, the language is awash with references to SMEs or small medium enterprises. Going back to my days in the SME group and so on, there was always some looseness about what was constituting an SME. Have things become any clearer?
Well, that's interesting, Tony. Not really is the answer. In lots of policy areas across Australia, there are many programs that target SMEs, but there's no uniformity around the definition of what is an SME across Australia.
So we've got a national cabinet, but still no uniformity. Is that right?
That's it. So indeed, in most states and territories, there are small business commissioners. They provide dispute resolution services to small and medium enterprise, but there's still still that doesn't create any uniformity in definition either. So with the adoption by the National Cabinet of this 50 million turnover criterion, that may perhaps in the future become a settled criterion for that definition. But I mean, it's interesting because that's, many small businesses would say that 50 million turnover is big business. It's not, not small or medium.
I was shocked when I saw that, and
yeah.
I think it'll still settle to something much lower than that.
Yeah.
Now, Annabelle, you mentioned this that the National Cabinet has adopted a code. What's this code?
It's a national mandatory code of conduct containing a number of principles, some overarching principles to guide landlords and tenants in their negotiations during Covid-19, and more specifically 14 leasing principles. So there's quite a few. Whilst it's not uncomplicated, it's also a little unclear in places, but it's far-reaching, and it fundamentally changes the balance between landlords and tenants in their negotiations in terms of leases. So I can read a summary of
Why don't you
those
go through them one
principles.
by one and have a bit of a talk about it?
Okay, so the first one to refer to is that rent should continue to be paid, and where there is financial distress by a tenant as a result of COVID-19, for example, the tenant is eligible for that assistance under the JobKeeper program, tenants and landlords should negotiate a mutually agreed outcome. And the key of the principles is to negotiate in good faith. However, as I
That's
said...
very, very vague. Very vague.
That's...
You could drive, any self-respecting lawyer could drive a truck through that. Oh, seriously.
This is all coming in stages, first with the Code of Conduct, with a number of mandatory requirements and some that aren't mandatory, but it's not yet prescribed in regulations, shall we say.
So this is sort of aspirational stuff.
Yes, that's what I'd say. And applies across Australia.
What else have we got?
So, secondly, proportionality is a key thing. There will be a proportionality to any rent reduction based on the decline in turnover of the tenant's business to ensure that the burden is shared between landlords and tenants. So, another thing is the provision of information and documentation. So this is going to require up-to-date financial information, and that can take a long time and a lot of work.
You couldn't get to first base without doing all your homework, and that could take months.
I know.
That's,
And we're talking about a 6-month period, so yeah, it raises questions about how does this all come about.
Okay, so
in
we're on a
time.
roll. Give us number 3.
Okay, the next one is a prohibition on termination of leases by the landlord, e.g. no lockouts or eviction for any non-payment of rent. That's a fundamental variation of any existing leases.
I'm just thinking of those poor security guys who normally get the job of turfing out the tenants. They just lost their livelihood.
Losing business themselves. That's an area affected. Now the next one is a freeze on rent increases, except for turnover leases. And if rents are market based, they should go down, not up.
Oh,
Yeah.
interesting. Yeah.
Yeah, there's lots of empty shops. What else have we got?
Another prohibition is on penalties for tenants who stop trading or reduce their operating hours, which is usually mandated in their leases between certain hours, for example, shopping centres. So there can't be any penalties for non-compliance with that. Another prohibition is on landlords passing land tax to tenants to pay if that's not already legislated. So most retail tenants don't have to pay land tax.
That's in Victoria. I don't know whether that's the case in other states and territories. Do they cop the land tax?
I'm not sure. I think it's different depending on the state and territory. Yeah.
But certainly not under our retail.
No, not under retail leases, no.
Another prohibition is on landlords charging interest on unpaid rent. Again, another prohibition on landlords is from making a claim to a bank guarantee or security deposit in the terms of the lease for non-payment of rent.
So lots of tenants would satisfy their security deposit obligations by providing a bank guarantee or something similar rather than cash.
Yes. So this is where the landlord may suffer. They're not all awash with money, and there's no assistance to the landlord under some of those principles that I've mentioned.
Just assumes
So there's lots of
landlords-
different pressure points where you can see things going wrong. can't you? And this little matrix of principles, they don't cohere into a coordinated code. It's sort of aspirational in all different directions.
Dispute breeding ground.
Yes, good for lawyers.
Yes.
Let's have a look. I've got just one more actually to go that I'll mention, which is the code seeks to ensure that any legislative barriers or administrative hurdles to lease extensions are removed, so that a tenant and a landlord could agree a rent waiver in return for a lease extension. And that goes through the principles.
Okay.
In summary.
Right. Okay.
We can look at the actual code to see the list.
Well, can you make some comment about where you see this going at the level of the principles? It's very aspirational stuff. Got any comments?
So what's coming next to enshrine them? Okay, so we've already had the Omnibus Emergency Measures Bill here in Victoria, which seeks to apply the principles under the code. However, what we've seen so far is some more certainty around definitions of an eligible lease, which adopts the two-pronged test under the code relating to being eligible for the JobKeeper assistance, as well as being an SME, as well as turnover up to 50 million, in reworded, so to speak, and perhaps with a little tinkering about some clarification on retail leases and retail commercial leases and non-retail commercial leases. That's in Victoria, but each state is going to legislate, and as I mentioned, the Act empowers the making of regulations, which are still to come.
That's right, so we're still at a very high level, aren't we?
That's right.
Okay.
One thing to mention about the code is that it provides for mediation where parties can't agree on the terms of a variation of the lease, applying the principles under the code. So that's something to be borne in mind. If you can't agree, then it will be referred off to mediation, and there will be a binding decision made at mediation.
Or can I correct you there?
Oh yes, please do.
There won't be a binding decision, it will be mediation, not adjudication.
Mediation and then opportunities to take it further.
Oh yes, absolutely.
Yeah,
absolutely.
I think that's right. Yeah.
Thanks, Tony. So again, landlords and tenants, they're going to have to craft their own deals, and that's where lawyers can help in terms of both negotiations,
Sure.
mediation, and documenting those variations.
Okay, that's a big haul. Thank you, Annabelle. Now, Megan, what happens if the parties don't sign up to the code? What happens then?
Well, we just don't know at this point, Tony. It's really a matter of waiting for the full suite of legislation to be released. At the moment, governments across the country are doing a mad scramble to legislate. That will take time. As Annabelle said, we've got the Omnibus Emergency Measures Act in
Really
Victoria.
rolls off the tongue.
It really
doesn't
does. Yep. But again, that's very high level. The devil is really going to be in the detail, in the regulations. But again, they've not been released. So, as I see it, landlords should be looking to keep viable tenants.
Yes.
Because if they lose tenants, it'll be difficult to replace them in the post-corona environment.
I agree with that wholeheartedly.
So the deals will need to be that will be struck will need to be less adversarial. They'll be more centred around collaboration than we've ever seen before, I think, in this space. Settlements will likely be more carefully crafted to build an enduring relationship. So that will be a big adjustment for landlords, I think. Okay.
Now, Megan, Annabelle's told us that the National Cabinet will be targeting tenancies where the tenant's eligible for this JobKeeper assistance. How does that all work?
Well, Tony, the federal government effectively, in terms of JobKeeper, is underwriting businesses by subsidising wages. It's only going to be expected that the federal government will look at tenancy arrangements. But again, that's a high-level statement and it doesn't really get into any detail.
Mm-hmm.
What I suspect is that much of the code stuff will prove to be after the horse has bolted.
Mm-hmm.
Parliaments will move slowly, but industry gallops ahead. This is why lawyers will need to be front and centre like us. Deals will need to be done in the absence of perfect information. So, Tony, what should prudent tenants do?
Well, before we come to that, Megan, what was the date of the Prime Minister's statement? It's about a month ago, I think.
Yeah, that's right.
And we've had very high-level legislation in Victoria and Western Australia. I'm not sure about the other states.
New South Wales, I think, might have just gone to.
It might have, but I think in each instance that the state legislation has been not much more than contemplating regulations. And the regulations have not seen the light of day.
Yeah.
And the regulations will have to go through a statutory process. And that's likely to take at least a couple of months because it's very complex. So we're then into May, June or July before we have the black and white law that governs these relationships. And in the meantime you've got tenants who've been motoring along or not motoring along and not knowing what their future is and not being able to know what the precise shape of the law will be for another 3 or 4 months.
And
so
it's going to sunset in 6 months.
That's
so
right.
What's the effect of that?
That's right. It's
If people don't get
completely up in the air.
in
So
3 months, you know, addressing
Yes.
the detail in the regulations,
so
how does that work?
well, my point is neither landlords nor tenants will know for months and will have to make decisions in the meantime. So this is by way of answering your question. So if I was advising a tenant, and of course no two tenants are the same, I would be saying do these things. First of all, get some legal advice because the ground on which you build your business is moving under your feet.
Yeah.
Secondly, get up-to-date financials done really quickly. Don't ring the accountant and put up with an answer saying in a month or two, or wait till the end of the financial year. No, you'll need them quickly. And make sure that the financials include a cash flow analysis that highlights the coronavirus hit. And also develop a business plan about how you're going to trade into the future from this unhappy experience. These are not with a view to being necessarily given to the landlord, but you can't make informed decisions without them.
No.
You also need to start the mediation process as soon as possible. The majority of them will be with the Victorian Small Business Commissioner, with whom I've got a lot of experience. But the problem with the Victorian Small Business Commissioner is they've only got the capacity to do 2 mediations at a time, and their facilities will be booked up in no time at all. So you will often need to find alternate facilities and offer them as a venue if you're going to get your Small Business Commissioner mediation. You need to keep in regular communication with the landlord because landlords get skittish, very nervous if the tenant doesn't talk to them and isn't paying the rent. They want to be made to feel comfortable. Keep talking, please. Of course, we all pray for a vaccine. And the tenants need to be transparent in their dealings with the landlord because these are strange days and the two parties will need to craft a deal that works for both of them. And that will require a degree of transparency that has not been characteristic of landlord-tenant dealings in the past. Most importantly, any deal must be recorded in writing. I think most leases mandate that, and it's required under the Instruments Act because it's an interest in land. And I suppose, drawing on what we were talking about earlier, Don't wait for the legislation because we don't have time.
Yeah.
Get to the lawyer and go very quickly.
Yeah. Great. Thanks, Tony. And what about landlords?
It's pretty much a similar story, except that landlords are not readily able to form a view about the viability of the tenant's business. They don't get the financials, they don't get the trading figures, and they're in the dark. And they will likely come to these discussions with a view of commerce and letting of properties that is born out of an environment where it was a landlord's market and there was a queue of tenants wanting to take their premises. The balance has swung and the uncertainty abides on both sides. So I think, again, landlords, get legal advice and quickly, because you don't know what the restraints are under the code, and you'll need the details of that, as Annabelle was talking about before. Immerse yourself totally in the tenant's business if you can. Find out about the industry, find out about the financials, find out about the competition. Be willing to mediate, because it's a hell of a lot cheaper to mediate than to go to court. Prepare for a discount. Don't wait for the legislation. Get on with it and do a deal now.
Yeah. Agree.
Now, to both of you, can you see a role for lawyers in all of this?
Well, Tony, these are really important relationships. They concern people's livelihoods. It's pivotal to both sides, landlord and tenant. So, yes, I think legal advice is critical. It's a must.
What about you, Megan?
I agree with Annabelle. I think change is happening really rapidly and it's complex. It's about making the best decision, and in doing that you need to seek advice.
Now, Megan, one of the things I've been wondering about, given the social distancing rules that apply, is how do you run a mediation when you can't get people close to one another? From my experience over many years, the mediators have always said that unless you can get everybody in the one place at the one time, the chance of your mediation producing a settlement is low. How are you going to get around that?
Well, Tony, there's a number of different technologies that the courts have been adopting for the last sort of month or so, and that we have been utilising here at Burke for some time. Microsoft Teams, Zoom, to a lesser extent Skype now, but we've been early adopters of all of those technologies here at Burke and have seen the benefits of it.
Right, that's good. I'm sceptical myself. I think
Give it a go.
there's often a moment in a mediation where people need to look one another in the eye and pick up on the body language, and it makes a difference. So Megan, you're heavily involved in the SME activities of the Law Council of Australia. Has there been any discussion in that environment about what this all means for SMEs?
Well, again, not in much detail yet, Tony. The leasing experts are all over it though, because it's breaking fast and it's pivotal. We do know, again, that there won't be any national uniformity.
Right, okay. Annabelle, the Prime Minister's announcement refers only to landlords and tenants, and those of us in practice know full well that the relationship between a landlord and tenant can impact on significant other parties. Have you got any observations about that?
There will be third parties involved, yes, and a key obvious one will be banks. So if a landlord starts giving concessions to a tenant, it might compromise its relationship with the bank. On the other side, tenants often have commitments to banks, suppliers and staff. So these can be impacted by the arrangements in the mandatory code of conduct that the Prime Minister announced. It's likely that in many of these landlord and tenant negotiations, there will be one or more third parties. Some may be in the same state or some may be overseas.
Yeah, well, it's more often than not the case that there will be a banker on at least one side, and usually it's a condition of lending that any fundamental changes to a lease or a business have to be approved by the bank. So we'll end up with a raft of multi-party mediations for sure. Then you have employees, then you have suppliers and all the others. So I guess, Annabelle, what starts off as a two-party dispute can easily involve many other parties.
And that could reduce the chance of doing a deal.
True. And it also emphasises the need for lawyers.
Correct.
Okay. So Megan, what happens if there's an agreement between the landlord and the tenant?
The most important thing, Tony, is to ensure that the agreement is reduced to writing and signed so that the parties are bound and it becomes enforceable. As you've both touched on, also if it's a condition in your loan documents with respect to the bank, then to notify the bank as well. At Burke's at the moment we're offering fixed fees for deeds of variation as a result of these agreements.
Right, there would also be franchisees who would have to be very careful as well, aren't there?
Absolutely.
So drawing it all together, we've heard from some very experienced lawyers, and it's clear that the economy is fluid, the law's changing, and there is movement afoot. And we at Burke and Associates have been dealing with such matters for over 65 years. And if you need any help, come and see us. Thank you.
Thank you.